know that's being recorded, but I will go ahead and turn the time over to Shanna.
Hello, everyone. Thanks for having me come on here. And it's the end of the day, so I'll try not to bore you too much. I know everybody's probably spent from today already, so we'll just get going. My name is Shanna Wyatt. I am the victim coordinator here at the Board of Pardons and Parole. I have been with the board for, oh gosh, probably about 18 years now. Off and on victim coordinator. I've done some other things here, but here I am with the victim coordinator stuff again, which I really enjoy it. It's I'm the only victim coordinator here. I'm the only victim coordinator for the whole state of Utah for the parole board. But again, this is a role that I really enjoy, and I've been here for so long that I feel like I can do it in my sleep, but then they always pop something new at me, and I've got to update this presentation, so bear with me a little bit. So I might go off track a little bit, but I'll try not to keep you too long. Okay, so like I said, I'm the board victim coordinator. I'm not a victim advocate. The difference is I cannot be a victim advocate for victims because I'm actually an employee of the board. So I have to kind of be in the middle, like, you know, just I'm here for information. I'm the point of contact for all hearings and victims, giving them information about when hearings are coming up, what they can expect from hearings, where they need to, you know, submit statements and things like that. I research updated victim contact information to make sure that I have the most recent address to give proper notification to the victims. I am required to give victims notification of all hearings, and doing that sometimes is really hard because a lot of parole hearings don't come up till years later and people move. We've started really getting involved with getting email addresses. I know email address has been around forever, but we barely got a little slot to put emails in. So we are getting email addresses in there. We definitely want to make sure we're getting in contact with these victims. And so it's like your roles at these other agencies is in your contact with victims to make sure that, you know, that they are contacting our office and getting us address. And I'll probably say that several times through here because it's so important to our notification process. I'm here to answer questions for victims that are preparing letters. I will set up, not really appointments, but phone calls. I go back and forth several emails to discuss specific concerns with victims. And I may attend hearings with victims if given advance notice, but right now, and I don't know if you guys have already heard from Laura Flanagan, she probably talked about the board. Me and her work very, very closely with each other and cases. She actually at this time is the one that will attend hearings with the victims due to she can actually advocate for them, where I can just give them information, but sometimes they do want somebody to help them put together a statement, to ask for that no contact, maybe ask for GPS monitoring, and she'll also follow cases and get them information as results come in. Those are just things that I can't do as the coordinator. So next we have what the victim's rights are for here at the board. They have the right to be notified of all hearings, which are like original hearings, which are the first hearings before the board, rehearings, they're pardon hearings. Sorry, I'm just trying to think in my head. Victim impact hearings, any type of hearing that we have, they will be notified of. The only hearing we don't notify of are parole violation hearings. And that's only due to the fact that if they're brought in on a violation, it doesn't usually concern or involve like the original victim. So if they're tracking them through Vine or keeping track of their offender, then they will find out about a parole violation hearing. We will allow those victims to speak at these hearings. We just don't provide that notification because we do have try and have a quick turnaround with parole violators. So there's actually not a lot of time to even notify victims sometimes of those parole violations. There is such thing as a parole violation original hearing, And that is if they're brought in on a parole violation, but they're also charged with something new. And if that new charge does have a victim, we will notify them of that new charge. They have the right to give an impact statement during the hearings. They can do that in writing or they can do that in person. They have a right to restitution. So they definitely have the right to submit any type of dollar amount that they are out of pocket for the crime committed against them. And they have the right to have like that open communication. So basically to call me, to email me, to, expect those that I'm getting back to them to make sure that they know these rights that they have. So the types of hearings that we have, and I kind of talked about them a little, is original hearing. That is the first hearing that they have before the board. All offenders, the minute they are put into under our jurisdiction, they do get an original hearing with the board, no matter what. Everybody sees the board. We have a victim impact hearing, which I'll talk about that in a little bit. We also have a rehearing. What a rehearing is they go to their original hearing, and if the board does not grant them a parole date at that hearing, they can grant them a rehearing where they'll say, you're not going to get a parole date this time. We want you to do this class, this class, this class, and we'll talk to you on such date. So they'll give them a tentative rehearing somewhere down the road. Restitution hearings, if the offender is denying amount of restitution, we will hold a restitution hearing. Or if the victim, if more restitution has come up and they want to get it added to the offender's restitution due, then sometimes we'll hold a restitution hearing for that. And that's another type of hearing that is held. We usually do those like once a month. They're not very often. A parole violation hearing, again, is if somebody violates, they have that parole violation hearing. And the parole violation / original hearing is if that offender comes in with new charges. Not only did they violate their parole, they also came in with new charges. And then we have the pardon hearings, which those happen weekly now. We used to only have them like once a month, and they're happening so often now that we do have those about once a week. Sorry, and I know I talk really, really fast, but if you guys have any questions, please just let me know. Okay, victim notice of board hearings. Hearing information is set 30 days prior to a hearing. We are required by law to give at least 30 days notice. That is to give, the victim and the victim's family time to make arrangements to attend the hearing and get involved with the hearing. VINE notifies a victim anytime a change is made with the offender. And I cannot stress enough to let people know that VINE does not at this time notify of parole hearings. Many, many victims think that if they're signed up for VINE, that they're going to get notified of a hearing. That is not the case. We only notify by now email and written. We never call about hearings. We are trying to work with VINE to maybe get this where we are part of that hearing notification, because people do move, and sometimes that we're the last person that they're probably thinking of that they need to update their address with. So hopefully in the future we can be part of that VINE system, but they will notify them, if they've moved or those basic things, or if something's changed, like their status has changed, then they'll call us and say, I got a notification from VINE. Can you tell me what's going on? But VINE does not notify of hearings at this time. So life without parole or death sentence get no original hearings. We don't even see them. With the courts, they got, life without parole. So we have no hearings for them. Initial notification is sent on first degrees if the hearing is set within the next 3 years. So this is a notification that is given, like I'm given the file of these first degrees, and if it is within 3 years, I send a letter out telling them, hey, your offender has been set an original hearing. It's going to be in 2024. Just wanted to give you a heads up. Here's this letter. Make sure you're updating your address with us. And we call that an initial notification. And we only do it on the first degrees because they're set out, a little bit further than some of the others. We also have an impact hearing notification, and that said if the hearing is out longer than 3 years. And we'll talk about the victim impact hearing also. I do have this hearing schedule here, and it's just really it's kind of confusing, you know, with everything that we're kind of talking about. But it kind of just gives you an idea that on a first degree, you know, felony, if it's 15 years to life, they most likely will not have their original hearing for at least 12 years. It just kind of shows you, you know, 10 years to life at 7 years, and so on. Like a first degree, 3 years to life, they will actually see the board at 12 months. And that is basically to get, so that they know what classes and what treatment that the board is looking at for them to get before they reach their minimum of the 3 years. And then as you can see, like the second degree sex offense up to 15 years, they also go at 12 months. And then second degree on all other offenses will go at 6 months, and the third degree at 3 months, which seems really, really soon for a lot of people, but it definitely is sometimes good for the victim to get involved that early, because then they know what they need to do in the process, and how much they want to be involved, and when the next hearing will be, and things like that. And this is just kind of a guideline of what the board looks at when making when putting in when they're supposed to see their first hearing. So we have board administrative routings. This is where the board sets an original hearing. It's a tentative month and year. They do this by majority vote after considering a pre-sentence report, a court judgment and sentence, other material available at the time of sentencing. And these are completed on the following. They're completed on homicide sentences, if the offender was under the age of 18 at the time of the offense, and any 25 to life sex offense sentences. These are the ones where the 5 board members will get together, they'll review these cases and set their hearings accordingly. So again, these are ones that they could not have a hearing for like 40 years. Like they just depending on how they're sentenced or what the case is. But these are the things that the board takes into consideration when making these decisions. So this is that victim impact hearing that I was talking about. If the original hearing is more than 3 years away, a victim may request a victim impact hearing. And how they find out about this is, so I talked about that initial letter. If the hearing is more than 3 years out, I will send them a letter and say, hey, you know, your offender is having a hearing in 30 years. Well, you know, a lot of people may not be around in 30 years, and they may want the board to hear their side, hear their statement. So the victim can actually request that we hold a victim impact hearing. They set that up with me. They're usually out at the prison. The offender is present, but that whole hearing is basically for the victim to give an early testimony if they want to, due to the fact that the hearing is so far out. We don't get a lot of these. A lot of people will send in a letter, which will go into the permanent file, but we do get them every now and then, where you have family members that are like, you know, we want something on the record because I may not be here when you have that first hearing. And then the board, and for future, the idea is the board will listen to that first hearing. So written victim statements, submit statements whether or not a victim attends a hearing. So I always let the victims know that this is totally up to them how they want to participate. They can either participate in person and make a statement with the offender in the room or out of the room in front of a hearing officer or a board member, or they can definitely send in a letter that is always placed in the offender's file. All statements are helpful for current and future board members because they do review them. Again, these hearings sometimes go on every 2 years, every 3 years. You know, they do review everything in the file. So it is helpful to have that written statement because for future board members. Copies of a victim impact statement submitted, I should say, from the courts. We don't always get victim impact statements from the courts. I think a lot of victims assume that if they made a statement at the courts that we have it. We don't always get them. It's getting better with electronic records and everything, that we are seeing them uploaded more and more, but it's not a guarantee that we'll get them. So I always encourage the victims to write a new statement or resubmit the one they did in court. If they want to do that, they can also do that. So victims' family members, supporters may write the board. So anybody can write the board. So I always let them know, if you have family members or anybody that is supporting you wants to write a letter, they can send it to us. And that, again, will go in the file, and the board reviews everything that we receive. There's one little catch to these statements, which is disclosure to offenders. So unique only to Utah by the Utah Supreme Court, the board must provide the offender copies and documents and information that will be reviewed for a decision. Everything we receive, no matter who it's from, the offender gets a copy of it. We do make sure that we take out any contact information, such as email addresses, phone numbers, addresses. We try and take out anything personal. Content of the statement is shared. So, I know it's really hard for domestic violence or even, sex abuse cases and things like that, that they don't want retaliation, or they don't want their family member that's in the prison to read what they wrote about them or things like that. I kind of just encourage them to get their statement in there, but try not to put too much in there that they think will, I hate to say upset the offender, but you don't really want to fuel the fire, but you want to let the board know how this has impacted you. And for a lot of victims, it's actually, they're like, let him see it. I want him to know, him or her to know how, what they've done, like, how I've been affected. So it's sometimes good and sometimes bad, but I never want to discourage a victim from writing into the board. But this right here makes it a little bit hard sometimes. Sometimes they have to get a little bit creative, which Laura, I know, is very good about helping them put statements together that are not, don't come across as, being like too angry or too, I don't know, like this is a hard one. I wish it wasn't here, quite honestly, because it's really hard to have to send in some of these letters to the offender. Victim's name changes from time of offense needs to be shared with the board. So if they get remarried or whatever, I will take their new name, but I always ask them, if you don't want him to know your new name, let me know. We will keep it in the records that the name that this person knows you by. We do try and protect them however we can. So hearing attendance and participation, all hearings are open to the public and are recorded. The Department of Corrections has their own security rules, which you need a photo ID to go to these hearings. Under 18 must be with an adult. No purses or bags and cell phones go into the prison. If assistance or accommodations are needed, they can let me know. We work with the prison really well out there at the boardroom. If they need an interpreter or anything, then we do try and coordinate with the prison to try and get what they need out there. Hearings are scheduled for 20 minutes. Victims are given 5 to 10 minutes to speak. 20 minutes is a normal hearing. If it's a loss of life hearing, those go for an hour. And yeah, they do. 5 minutes sounds like not a lot of time, but it actually really is. They don't usually go over that 5 minutes. I usually have them write out their statements so that they have something to read at the hearing. I think it makes it easier for them to make sure they get everything out that they want to say. And then also they can submit that statement and it's put in the permanent file for future board members to read. Victims can make a statement with the offender in a holding room outside of the hearing room. So if the victim is not comfortable speaking in front of the victim or in front of the offender, they will remove the offender from the room. He sits in a different room. He can still hear what they're saying, but they don't have to sit there and speak while he's in front of them. Just whatever makes them comfortable. We really are trying to make this comfortable for them because these are not fun hearings for a lot of these victims to attend. Victim representatives. So who can speak at a board hearing? A victim, parent, if the victim is under the age of 18 at the time of the hearing. A representative that a victim over 18 designates. An immediate family member if victim is deceased is like a spouse, children, parents, siblings. Basically, if mom calls and says, you know, I want to speak on behalf of my daughter, my son, we'll let them. Like, as far as representative, a lot of, you know, people over 18, if they're just not ready to speak at these hearings, they can definitely let a parent speak for them. And then anybody else can send in a letter. We only allow one person to speak at these hearings. At loss of life, we do allow 2 people to speak, and everybody else can write a letter to the board. So how can you help as a victim advocate? So informed victims' families can write to give further input. So just let them know that they can, victims and their families can definitely write into the board at any time. It doesn't matter when their offender is going to the board. We print or upload or whatever. We're getting into electronic records now. We're a little slow, but we're barely getting into getting stuff into electronic. So we'll make sure that they're in that file, no matter if it's paper or uploaded. They can write anytime, even if they've written 2 letters, 5 letters, 10 letters. If they have something that they want the board to know, have them write a letter. We just take it all. Victims are responsible to keep contact information current with the board. So again, addresses are very, very important to us. We are required to give written notification. So we have to send those letters out. And I'm telling you, I'm sending out about 200 letters a month because we do hearings on Tuesdays and Thursdays. And each week there's probably 40 hearings. So we're sending out a lot of letters. So we get a lot of letters back. So trying to keep up on return mail and making sure those get out again in time is brutal. So anything we can push to get those addresses updated is so much appreciated. We do have a victim email here at the board, and it is bopvictim@utah.gov. Those come directly to me. I check them every single day, all day long. They can update their addresses there. There's also a place on our website that they can update with. They can send victim letters there. They can ask me questions there. That is just kind of a go-to spot if, you know, they don't want to make a phone call or they just have a couple questions. There's also a form on our website that they can go to. And the website is bop.utah.gov. And I actually highly recommend that if you guys are at all interested, all of our hearings are live broadcasted from our website, and they're every Tuesday and Thursday from 8 to 5. And you can just log on there like a Google Meets and go watch a hearing, go watch a few of them just to see what to expect. So you can tell your victims, this is what's going to happen. Once he has a hearing, he or she has a hearing, and this is what you can expect. This is how, you know, to say that you've watched them and know that what's going to happen makes it so nice for the victims to understand, you know, what to expect from these. That's probably my main question from a lot of victims is, what's going to happen? How do these hearings work? Like, what can I expect from these hearings? So I highly recommend that you go to our website, and it's the bop.utah.gov, and it says live broadcast, and you just click on those. And again, they're every Tuesday and Thursday from 8 to 5. And Wednesdays are parole violation hearings. So again, they're a little bit different. There's an attorney involved. They're also interesting to watch just to see, you know, a lot of victims are very concerned when their offenders violate a parole, like what happens next. So definitely that's one that you can go watch as well. Dang, I really flew through that 25 minutes.